just got a $50 million verdict from Starbucks for a gentleman that he was representing.
Prosecutors really have to just prove one or two things, either that he's a flight risk or that he's a danger to the community.
And you got a fantastic result, which aside from getting a not guilty, getting a dismissal is one of the best results possible on a criminal allegation.
He smiled. He said, hey, I never heard that one before.
There was a misunderstanding. There was a verbal altercation, but at no point did I ever engage in a physical assault.
Client was charged with indecent exposure. Class B misdemeanor, but obviously it's a...
Immediately, it sounds bad.
It sounds bad.
We have a situation where we have a 911 call, but it's not from the person who they claim is a victim.
I went to bar 5015, poured gasoline, which caused the bar 5015 to literally explode.
And instead of us just simply asking for this $250 that you guys did not want to settle for, we're now asking for the true value of the case, and we're asking for $50 million.
You know, do not make a statement whether it's a civil case or a criminal case, because the other party can still use your statements against you.
They are still presumed innocent in my book. Why? Because they have not been found guilty in any way.
To present the best defense, you know, you got to be able to focus, you know, no distractions, not multitasking. That's just me.
He makes the decision to, unfortunately, tase this person.
He came out and said, hey, all these accusations are lies. They're all lies. Then the video comes out, okay, yeah.
I just don't think that this argument's going to work here,
right.
Corian. Everyone, welcome back to Unlocking Success. I am here today with our associate lawyer, Mr. Corian Johnson, who, by the way, has been executing at the highest levels possible here, guys. We're talking about result after result, successful result, by the way, for each and one of our clients that have had the pleasure to have Mr. Johnson leading their case. Now, this is part of the reason why I wanted to make sure that we had an opportunity to go ahead and feature Mr. Johnson today. One, because I want to make sure that you guys have an understanding as to what exactly is the mindset, the habits, and the discipline, more importantly, that it requires to be able to execute at high levels. And so, Corian, welcome. How do you feel today? You doing okay?
Doing good. It's Friday, so, you know.
It's Friday.
Hey.
It sure is. And we're in the headquarters. It's after 5:30 p.m., guys. We're all sharing rides. No one's driving, so we're enjoying a nice little cup here of a little bit of juice. That's what it is. But we're having a good time, guys. So mindset and habits. On that note here, Corian, what do you think so far has really allowed you the opportunity to say, this is what I need to do day in, day out to be able to obtain excellent results here for our clients?
I'm glad you brought that up. I think the main thing is, I actually got this from one of my good friends, Kenneth Stevens.
Okay.
I know he said it that, you know, he's an entrepreneur, but he says one of the things that he always found successful was finding the white noise, is what he calls it. So pretty much just go where everything's quiet so you can make your impact. So with me personally, I think for my white noise, it's either early in the morning, late at night, when the phone's not ringing, you know, I'm not being bombarded with a lot of different, you know, stimuli, people asking questions about their case, which is not a problem, obviously. But, you know, sometimes to really research and find the answers in order to present the best defense, you know, you got to be able to focus, you know, no distractions, not multitasking. That's just me. That's not really my strong suit. So I got to make sure I really just take advantage of the white noise where everything's slow. Let me get the answer. Let me read these facts. Let me create a timeline of what took place, when it took place. Like for DWI case, when was the blood draw? When was the time of the traffic stop? When was the time of the blood draw? You know, can they extrapolate, you know, back to what our client's blood alcohol concentration was at the time of driving? Just getting these facts and just learning them.
So essentially placing yourself in a position that allows you to have a clear mind.
Correct.
Clear focus.
Clear focus.
Have a clarity of goal in mind.
Correct.
That you want to accomplish, and just go all in.
Correct.
When I say go all in, dissect everything to the T and get ready to go.
Absolutely.
Meaning, is there flaws in the state's case? Are there procedures that were potentially committed by mistake from these officers, or maybe by omission in some cases that we have found, where we can then take action and highlight these mistakes and these issues, potentially some legal violations as well, that will then allow us to make arguments to obtain these successful results. Matter of fact, one, you mentioned DWI right now, one case that, to be quite honest, this was an argument that you had made, and I thought, I just don't think that this argument's going to work here,
Right.
Corian. You know, we've been making all types of arguments, and this one's just not one that I think is going to hold any water at all whatsoever. And sure enough, you presented that to the prosecutor, and you got a fantastic result, which aside from getting a not guilty, getting a dismissal is one of the best results possible on a criminal allegation. Walk me through what exactly was that argument, please.
I know you're talking about. This is an argument that we made for a DWI case. So the elements had to prove that a person operated a motor vehicle in a public place while intoxicated. Now, in this case, client is driving, car runs out of gas, the car's on the side of the highway, and then so when the officer comes and makes the contact, he begins the DWI investigation. The argument that we made to the prosecutor is that, hey, we believe there's an issue with proven operation because this car is not drivable. Now, under the statute, they don't have to prove that a person did drive, only that the car is operable, capable of being driven, and then basically is under control of the client. So basically, when I was reading the office report, the officer highlighted that, hey, this car is running out of gas, not operable. For some reason, that just kept sticking out to me. Just after reading all these, police reports over the course of years, I was like, why does this keep sticking out to me? So I was like, okay, operation, that's the issue that we need to focus on. So I presented to the prosecutor. He smiled. He said, hey, I never heard that one before. And then so he did the right thing. He said, hey, let me take it under advisement. Let me think about it. Let me see if we can research. So finding case law that's on point to, I guess, to try to counter my argument, but he was unable to. So he was, after maybe like 2 or 3 weeks, he looked into it. He was like, okay, counsel, I'll file dismissal.
You made a good point, right?
Right.
That's fantastic. But it goes back to what you just said, which is really finding a zone that may work for you specifically.
Right.
And just going all in. I'm big on making sure that I focus on day in and day out, operating at a high level with clarity and a mission in mind. And for me, as you understand, purpose in wanting to have this massive reach for folks who need our help.
Mm-hmm.
And I have found that, I know you mentioned clarity. Early in the morning for me works best. Just as you stated, everyone's asleep and I'm up hustling, grinding, looking at how I can get better. Aside from not having, that distraction and giving me the opportunity to truly focus in and hone in on the issue or the goal in mind, it really gives me an edge personally. Meaning I feel like because I'm putting myself through that rigorous, wake up of, I need to wake up before everybody else.
Right.
And I need to focus on, trying to be better than yesterday. I walk around with this edge in mind that I'm actually ahead because of that thought process and because of those efforts that I am executing consistently, even though trust me, there's been days where, man, the bed is so good. It's warm. It's cold outside. Exactly. And you're just like, man, I need to just kick back. But no, kicking back won't allow you to move forward.
Mm-hmm.
And so it's been one of those things that just for me, looking back at, my experience, the challenges, the obstacles that, I've been encountered and ultimately overcame, I have found that that's part of the reason why, because I consistently focus on day in, day out, how I can get better. Is there anything else that comes to mind when I say mindset, habits that on your end have allowed you to execute?
I mean, it's just cliche, just taking it one day at a time, protecting our mind. I know we talk about mindset, but just protecting your mental energy. Because that's our greatest asset, Could be able to think clearly, there's a lot of different moving parts. We got a code switch on 3 different levels. I was telling this to someone the other day. You got to know how to speak to the client. Then you got to know how to speak to the prosecutor. You got to know how to speak to the judge.
Mm.
You know, hey, I'm not just some slimy defense lawyer trying to lie for my client. No, I'm actually presenting a valid legal issue. And that's how you got to build your credibility. But it all starts with a clear mind. Sometimes we may not have the entire staircase in front of us. Sometimes you have to think on the fly. You're not able to think about that or think with that level of precision and that level of efficiency.
Right.
You know, when the time comes, if you're not protecting your mental clarity, your mental, headspace.
Good point. That's an excellent point. I mean, I'm going to be sincere. I actually, over Easter weekend, I had a small getaway with my family.
Right.
Because it's required.
You got to rejuvenate.
Exactly.
Yeah.
Restore, reset,
and
let's go. And sure enough, small getaway, it allowed me to get back in full force.
Mm-hmm.
And full steam ahead, guys. This is what you guys need to focus on when you're trying to accomplish something that requires excellence.
Right.
One of the things that we were talking about before we even started, we mentioned and discussed BOBA, which is be obsessed or be average.
Mm-hmm.
Be obsessed with what it is that you want to accomplish, have a clear goal in mind, and just go all at it. Because otherwise, you're going to be average.
Mm-hmm.
Now, don't get me wrong. I don't have anything against being average. If that's the case that you wish to have or prefer to be, then by all means, go at it. But for us, the folks who are watching, the folks who are interested in becoming the best that they can be at their particular niche, their particular industry, this is what's required. Being obsessed, having clarity, having focus. It's going to be part of attaining success, guys. Now, let's move on here in regards to some case results that we can detail and highlight. Because, making sure that we have that clarity and these habits and mindset in mind, ultimately it allows us to be able to get some good results.
Absolutely.
One that comes to mind, this is actually just last week. We had a case that we had set for trial where our client, as you guys understand, we deal with both criminal defense and personal injury matters. We had a particular case on the criminal defense side where our client was being charged and accused of having committed assault against a family member. In the state of Texas, that gets classified as a Class A misdemeanor, as we understand. But this is a situation where all along our client maintained his innocence. He says, look, I understand the allegations are shocking, to be quite frank, but I didn't do these. I didn't do what they're alleging. I did not. This is just a completely blown out of proportion allegation. There was a misunderstanding. There was a verbal altercation, but at no point did I ever engage in a physical assault. And so sure enough, we, made it abundantly clear to the DA's office and we said, look, our client is of this position. And, so far we've looked at the evidence and we're of the position that you guys cannot prove this case beyond a reasonable doubt. So we're setting it for trial. They asked for an opportunity to evaluate the case. They want to determine, okay, well, let me make sure that we take a close look, really place that emphasis on what they're telling us. Just like you stated, this is not just some slimy defense. Rather, hey, they're being serious about it. Well, let's be serious about it as well.
Absolutely.
Which is something that I also appreciate from the state side. The DAs, there's some prosecutors who will really give you that opportunity to just make sure that, they focus in themselves and say, okay, well, do we really have a case? Do we really, have a situation where we can prove beyond a reasonable doubt before a jury of our peers? And this prosecutor who was assigned to this case, he says, all right, let me go ahead and have this opportunity to evaluate it. And sure enough, he came back and said, look, we have a situation where we have a 911 call, but it's not from the person who they claim is a victim. Rather, it was some person who heard something. Once again, verbal altercation. But they didn't see anything. They just heard loud yelling. They were worried. They said, let me call 911. But they didn't see anything at all whatsoever. Once officers get there, there's an understanding that, hey, there was a verbal altercation, but the person makes it abundantly clear, the alleged victim in the case, this is just a misunderstanding. I don't want to move forward. I don't want to do anything. But officers communicate this over to the district attorney's office. And I think there was this potential confusion or miscommunication where ultimately our client ends up getting arrested and charged. He then looks at the totality and says, well, wait a second, there's no medical records. The person who is listed as a victim has made it abundantly clear to our office they don't want to move forward. They don't want to testify. They don't want to have this clear understanding that we believe was actually the assault. And so in looking at everything closely, he says, look, you're right. I just don't see that we have a case that we can prove beyond a reasonable doubt. And sure enough, we walked out with our client. His freedom was preserved.
Absolutely.
His liberty, his rights, reputation in the community.
Most importantly, right. Most importantly.
Because, nowadays, anybody who gets arrested, charged, immediately you get convicted in the news, in the media.
Absolutely.
Well before you even have your first day in court. And so I was extremely happy that we were able to accomplish that. But this was accomplished by way of making sure that we executed on our goals, on these habits, day in, day out. Let's study these. Let's outwork. Let's stay ahead. Let's analyze and evaluate, and ultimately got to this resolution. Anything that comes to mind here, recent result that you can share with our audience?
I think first thing that comes to mind is another case set on the trial docket in Montgomery County, and I'm getting dismissal. Client was charged with indecent exposure. Class B misdemeanor, but obviously
Immediately, it sounds bad.
It sounds bad. It sounds terrible. We went through the evidence, just dissecting everything, went to the police report. One thing that we noticed that caught my eye was that what the officer wrote in the report was different than what was described on his body-worn camera. So we initially spoke to the complaining witness who alleged that our client exposed himself to her in a drive-through of a fast food restaurant. Basically, what she said on that day, it doesn't meet the elements of a crime, the crime that he was actually charged with. Now, one of the things that this officer did was that what I never seen before in my career was that he told this complaining witness on the scene, hey, based off your statement doesn't meet the charge of indecent exposure, but if you'd have said X, Y, and Z, we could have filled all those elements.
Sounds like coaching.
Exactly. It's exactly what it was. So, needless to say, 2 weeks later, she comes back with a statement that fills in those gaps that was originally left, even though on the day of the incident, she stated that she didn't see anything. She wasn't really trying to look. She didn't observe certain things, and obviously all these gaps are filled in. So that's one thing that stood out. So we made sure we presented that to the prosecutor.
Sure.
And then like you said, outworking. I put together timestamps of the original statement, the coaching from the officer. Just to make it easy to buy. One of my first legal jobs, that's what the owner, he used to always say, hey, when you're trying to sell something to someone, make it easy to buy. So that's what I had to do with the prosecutors. I know they're busy. They're dealing with 1,200 cases, caseload, sometimes more.
Some very serious cases too.
Serious cases. I know they don't have the time to look at everything unless we bring it to their attention. So that's what I want to do, just make, hey, I presented these timestamps. Go watch the video. These are the important sections I want you to focus on.
Good.
And then just to corroborate my point, again, you got to establish the credibility so they know, hey, this guy's presenting there's a very serious issue here. I'm not just trying to, trick him through smoke and mirrors.
There you go.
Because a lot of times, sometimes lawyers, we're not trusting of our colleagues, right? Especially when they know that we're biased and we're, we have client expectations, but you definitely want to make sure that you, again, just say, hey, I think we have an issue here. And once you lay those issues out, sometimes the prosecutor may not agree and you got to be ready to go to trial. But in this case, the prosecutor ultimately looked at the evidence and agreed and ultimately found a dismissal in the case.
Fantastic result. It sounds like you played an angle there where most lawyers don't really want to engage in showing their cards.
Mm-hmm.
Some lawyers that I've encountered are more of the position to say, well, we really want to, let the other side know what exactly I'm going to do in court or what I'm going to do in trial. And they just wait until the very last final minute, or they wait until trial to then show their cards with the hopes that, they can have that edge. Have you found in your career that it's best to just let the prosecutor know clearly this is the issue? This is the weaknesses that you guys have, where you won't be able to overcome and attain that high level of burden that you guys have, which is proving the case beyond a reasonable doubt in a court of law. In your opinion, in your objective, experience, is this something that you prefer to just simply show your cards and say, hey, this is the issue? Or, you know what, let me hold this tight until I am in trial and I'll show the jury, catch them by surprise?
I think it's both. I mean, the reason why I think it's better just to be upfront is because, one, on the defense side, a lot of clients didn't want to go to trial. The fear of the unknown. Even if you, explain the issue to your client and say, hey, I think we have a good shot at trial, they
don't want to go.
They want certainty. They want 100% certainty. Can you guarantee me this? No, can't make any guarantees, but we can just give our legal advice, our legal opinion based off our experience. So, and then I take this back to the other angle. I was a former prosecutor. I had defense attorneys who would straight up with me and say, hey, these are the legal issues.
Good.
And I always appreciate that, because I had defense attorneys who like to, just surprise you at trial.
Try to play some games, huh?
Play some games, engage in deception, which is fine. But then, it's like the story of crying wolf. When you're really serious about the issue, if you had that reputation of, trying to trick the other party or giving a defense that is not valid, trying to trick the other person, obviously I may not be inclined to listen to them. So that's why I always want to just, again, establish credibility with the prosecutor and with the judge. Because if they believe you know what you're talking about, they're likely to give you consideration. Okay, this guy's thorough, he's straightforward. If you say there's an issue, then,
that's clear cut,
right,
as can be. I was reading this book. It's called Running with the Bulls. Shout out author Nick Rowley. And just top lawyer. Matter of fact, this is the gentleman that I was telling you who just got a $50 million verdict from Starbucks for a gentleman that he was representing that unfortunately sustained very severe burns for getting some coffee spilled over in his groin area, had some dysfunction, and ultimately they ended up with that massive verdict. But he has this book that he highlighted this particular story about being straightforward and being upfront with the opposing side. He says there was this one particular case that he was handling where, as you understand, certain policies that cover automobile have certain limits. And in this case, they were handling this one particular case. There was a commercial vehicle, but the limits in that particular state, California, they only had this policy who had a $250,000 limit.
Right.
And unfortunately, this dealt with a case where it was mom who was driving and she had a passenger. It was her little girl. And who ended up severely injured was not mom, rather the little girl.
Right.
And medical expenses well exceeded the $250,000 policy.
Correct.
And so this case was referred to them because what had happened is that the lawyer who had originally been retained on the case, they made a proper demand, which, by the way, on the demand side, there's particular items that need to be within in order for you to try to open policies. Let me try to break that down here for you. So this was a situation where they demanded the entire policy limit, $250,000,
right,
based off of the extent of the injuries, the extent of the medical expenses, and then ultimately pain and suffering, mental anguish, the future loss of earning capacity, loss of enjoyment, all these non-economic damages that were also argued. And they said, hey, look, you need to give us the limits. And they gave them ample opportunity in written format to evaluate. They gave them all these records. And sure enough, the insurance company comes back and says, no, we reject your demand.
Right.
So what this gentleman did, this lawyer says, all right, well, let me look for one of the best. Sure enough, found Nick Rowley, his firm, his team, and they talked it over with them and they said, look, this is what's going on. So they had this claim now, what they believe to label as bad faith, meaning, hey, we gave you guys an opportunity to get this settled well within the limits. We gave you all the proper documentation so that you can properly evaluate. We gave you time, and yet you come back and reject this? All right, we're going to file suit. They file suit. They get into the case. They immediately start working where he was, at least in the book, he wrote out, they invested over $300,000 in hiring experts, medical experts, to fully dissect the injuries, fully prepare these medical reports. And instead of hiding the ball, they were telling the opposing side, the lawyers who were representing this insurance company, this is what we're going to do. This is what we're going to show. Matter of fact, here's a copy. We just got this report from our medical. Here's a copy.
Right.
We just got here's a copy. And this is what we're going to show the jury. And instead of us just simply asking for this $250 that you guys did not want to settle for, we're now asking for the true value of the case, and we're asking for $50 million. They went from $250,000 policy limit that they rejected on that demand.
Right.
They're now asking for the true value of what they believe to be the true value of that case, which is $50 million. The insurance company all along, it took them about 8 months, if I'm not mistaken as to what the book stated, in preparing everything accordingly, but all along they were telling this opposing side, this is what we're going to do. And that way it was abundantly clear to the opposing side, if you guys don't give us this, we're going to ask for more than $50 million at the jury.
Right.
At the jury trial. Sure enough, the understanding is that they realize, man, these people are serious. They know what they're doing.
It's a lower burden to prove.
It's a lower burden to prove compared to beyond a reasonable doubt. Yes,
Right.
sir. But they have invested
On top of that, yeah.
on top of that. So they're serious about what they're arguing, guys. Sure enough, they come back and they offer $45 million. From what the insurance company should have settled at the limits of $250,000.
Right.
They ended up paying out a $45 million
Yeah.
settlement amount. I'm like, man, wow. But that, once again, it shows that there's really different ways that you can go about it. Either, hey, just being straightforward and honest, and this is what I'm going to do, and I'm showing you how I'm going to do it and how I'm going to present it. And here it is, guys. Here it is.
Right.
Or let me be a little bit more reserved. Let me kind of, take back and show my cards. It could work.
And then possibly, in addition to that, it's just respect that the lawyer for Starbucks had for this opposing counsel. Because if they believe that you're not good at trial, or maybe you're afraid of public speaking, maybe you don't really know the rules of evidence that well, I may say this guy's not good at trial. Well, I think we can.
That's a good point.
I think we can take him. Even though theoretically we should lose, but
matter of fact,
because of this,
we have a new lawyer that just joined our team, and you guys will see him soon enough. But I was explaining to him. I said, look, matter of fact, we assigned one of our clients' cases to the point where we're still involved. This is how we operate at our office, right? We want to be involved. We want to look at what's going to be the best legal strategy. Let's, have his opinion, my opinion, somebody else's opinion, and really come up with the best legal strategy to execute on. I told him on his first day before going to court, and I said, look, this case involves a concentration of alcohol that is at 0.07. We've looked at the video. We've looked at, our client's reactions, mannerisms, how he was cooperating with these officers. There's no loss of normal use of either physical or mental faculties. And now that they have this 0.07, you need to go in there and demand this case be dismissed. But if you go in there and you demonstrate that you're not serious about moving forward to trial or trying this case, and that they sense any fear whatsoever,
Exactly.
they're going to take advantage of you. So please make sure you execute, stand your ground, and show them that you're about it. Because otherwise, they're going to go ahead and just simply run all over you. And isn't that the case? Don't you agree?
Absolutely. Yeah.
That is the case. And so now, speaking of that, there's quite a bit of cases here that unfortunately, are all over the media. And these are local cases.
Yeah.
One that comes to mind, Corian, is, matter of fact, that just came out today, is the understanding that one of the owners of what we believe to be one of Houston staples, Turkey Hut, has been indicted, is the understanding, or at least formally charged at the federal level. What has he been in charge with, though? What has he been indicted with?
So he's been charged with conspiracy to commit arson, and also conspiracy to commit arson to a vehicle using interstate facilities. Now,
so what happened?
The government is alleging that he he recruited the individuals who went to Bar 5015, poured gasoline all through the building. This is early mornings, it's around 4 a.m., set it on fire, which caused the Bar 5015 to literally explode. You know, neighbors are around that. There's apartments and condominiums and townhomes that's around Bar 5015. They're woken to a loud boom. You know, just imagine you're waking up out of your sleep, you hear this loud explosion, and then this business that was once there is literally
gone,
reduced to rubble. You know, so this happened back in 2020 during the pandemic.
But he's now barely being charged.
Correct.
Walk us through that insight, because I know, you know, we have an understanding as to how cases get charged at the state level, but it's a lot more meticulous at the federal level. Walk us through that a little bit, please.
Correct. So arson can be a state case or a federal case.
Okay.
What allows this to be a federal case is that if you intentionally set fire to a building that's engaged, a commercial building that's engaged in business activities, because typically with the feds, you have to affect interstate commerce. So you have a business that's, you know, buying liquor, buying food for different vendors that's crossing state lines. Now you enter federal jurisdiction. And obviously this is a high profile case. It caused a lot of damage, upwards in excess of $750,000. So probably in the millions that caused damage to repair. So
it's one of those incidents that, you know, unfortunately people get involved with, and now he's having to face these very, very serious charges.
Correct.
Is there a likelihood that he's going to get a bond?
I don't know, something like this. I doubt it. I doubt it, because you remember these are federal judges. You know, they don't have to run for re-election. They're appointed for life as long as they don't have any type of misconduct. But I think it's too high profile. I mean, something like this, you're clearly a danger to the community. So the feds really have to, prosecutors really have to just prove one or two things: either that he's a flight risk or that he's a danger to the community. Now, based off these allegations that you're recruiting people, you're paying people to commit these atrocious crimes on your behalf, obviously I think the federal prosecutors can check the box of danger to the community. You know,
clearly,
flight risk
floated.
Flight risk. I mean, he has ties to the Houston community. Okay. He has kids. He's a native of Third Ward, Houston, Texas. So he has businesses here. So I don't think he'll be a flight risk. Everyone knows who he is. But as far as a danger to the community, I think federal prosecutors may be able to convince a judge that he's a danger to the community.
Matter of fact, Corian, just to paraphrase here, I'm looking at the press release that was issued here from the Southern District of Texas. It says, former Turkey Leg Hut owner indicted for arson. Lindell Lynn Price, former owner of the Turkey Leg Hut, who now owns the Oyster Hut. I didn't know that, huh?
Yes.
Is set to make his initial appearance before U.S. Magistrate Judge Dana Hannibis, Palermo, at 2 p.m. Wow, today. Understood. Yeah. Also in custody and set to appear are Armani Williams and John Lee Price. Looks like what they're alleging specifically is that back on June 12, 2020, Price had allegedly recruited a group which included Williams, John Price, and others. We don't know. Essentially, these folks are still out and about within the county and the community. The charges alleges Williams, John Price, and others were involved in pouring gasoline at the entrance ramp before igniting a fire at Bar 5015. This is what they have now involved themselves with, having to face. Now, as you guys understand, look, I'm a big proponent on the right to be presumed innocent, right? And so even though they're now facing these very serious charges, as you understand, they are still presumed innocent in my book. Why? Because they have not been found guilty in any way. There's just allegations. Now they're very serious allegations.
Right.
So hopefully they get serious about getting proper representation to then face these and confront these allegations to hopefully then find a viable solution for them. Which brings me then to the next article here that, you know, once again, recently released. This also involves, unfortunately, another restaurant here that is also somewhat of a staple. This is Ojos Locos. There was a tasing incident where one of the security guards I'm not too sure the location, which one specifically in the city of Houston, because I know there's at least 4, if I'm not mistaken.
Yeah.
They got the north side, the south side, east and west. But ultimately, at this one particular location, the security guard had an understanding that potentially the gentleman who he ultimately ended up getting, or tasing, I'm sorry,
Right.
either was engaged in a dine and dash situation,
Right.
but he makes the decision to unfortunately tase this person and ends up getting arrested for unlawfully tasing this person. What was he charged with, by the way?
From my understanding, it's a regular misdemeanor, assault causing bodily injury, which is a Class A misdemeanor, punishable by up to a year in county jail or fine not to exceed $4,000 or both. But yeah, even if this individual did engage in some type of dine and dashing situation, I don't think he would have been, justified in deploying a taser on this individual. So
No.
if these allegations are true, then I mean that's going to be an aggravating factor.
Very much so.
And
I mean, I think that if anything, he could have, if he felt that there was some type of imminent threat, I could see the argument for self-defense, but just, oh man, I thought this person was just dining and dashing to engage in tasting someone. That's just not enough. I mean, not from what I can see so far. So once again, this is just, looking at some media articles here. We don't know the true facts of it, as I'm sure you guys don't either, but you want to, wait exactly to see what is the evidence that will be presented by the DA's office and ultimately, respect the fact that this gentleman here, even though he's charged, he's still presumed innocent at the end of the day.
Absolutely.
Good deal. Now, we deal a lot with folks who are facing investigations.
Mm-hmm.
And these investigations, in some cases, may lead to formal charges getting filed or, if handled appropriately, potentially cleared up and there's no charges that get filed. And what we do as part of our service here is that we offer what we label as pre-charge representation, where if there's an understanding that there may be an inquiry from state agents, and that can include officers, investigators, detectives that may want to talk to you specifically, and that there may be some type of, allegation towards you or some type of investigation that may lead somebody to believe that you committed an act or was involved in some type of act that ultimately they claim to be criminal, you're going to get this urge to say, well, let me make my statement. Let me make the effort to clear my name up.
Mm-hmm.
But as we just explained, the media can immediately pick up any statements, or specifically state agents may get some statement and think otherwise, or think, wait a second, he just confirmed that he was at this location, he or she, or, there's this understanding that there's inconsistent statements.
Right.
Maybe because you're nervous and in your effort to say something, you say it one way and then you repeat it and you say it differently. And now it's like, wait a second, didn't you just say something otherwise? So what you want to do is you want to have formal, professional, legal guidance that can do the talking on your behalf. Corian just mentioned right now, the first time that, a jury or a court, is going to hear from you, it's going to should be a trial. Rather than you trying to immediately, paint this picture or make your statements that can potentially be taken out of context, you want to have professional legal guidance do the talking on your behalf. And what we do is that we then establish that communication with the state agents and, make sure that they understand that you're invoking your legal rights to remain silent, so that we can then properly understand, well, what exactly is the inquiry? Why do you want to talk to this person? What are you looking for? Why don't you talk to us? Let's get a proper understanding before we, provide any type of statement. Let's look at this closely.
That's why every lawyer who's worth their weight in gold is going to say, hey, do not make a statement, whether it's a civil case or a criminal case, because the other party can still use your statements against you and it's coming in, so you definitely want to make sure that you exercise your right. One, you're paying a lot of money to these professionals. You trusted them, you chose them, listen to their advice,
Let's stop right there. Listen to the professionals, please.
Absolutely. Yes. Because you don't want to, because a lot of people try to talk their way out of trouble and end up making it worse. In these situations, I think one of the things you got to look at is, okay, the only way I can get myself out of this hole is just stop digging. Just take a step back, understand you're not in control. Once a legal proceeding has been filed, you're not in control anymore. Let your lawyers do the talking, let your lawyers get to the bottom of everything, and then we can analyze and dissect the case and present a valid legal defense on your behalf.
Absolutely.
That's the only thing you can do at that point. Trust in your professionals. You hired them, you interviewed them, they answer all your questions, made you feel comfortable. You spend a lot of money, you're investing.
Yep.
So trust them.
Investing in your freedom at the end of the
Right.
day, guys. Make sure you take that guidance and take it seriously. Don't make any statements whatsoever. Invoke your rights. Remain silent.
A good example of that, I know we have the federal case with Diddy. Initially when these allegations came out, he was making statements. I know it's hard for him to sit quiet. It's not his personality. But he came out and said, hey, all these accusations are lies. They're all lies. Then the video comes out. Okay, yeah. Video comes out.
There was a follow-up video out of Ollie, if I'm not mistaken.
Now you got
an apology. It's like,
now you're caught in a lie. Now they're saying, hey, if you lied about this, what else are you lying about? Now it's like you want to maintain your credibility. It's crucial in these type of situations. You're not going to defeat social media or the internet. The media's going to do their job. They're going to try to sell the salacious story. Sometimes you just got to bite your tongue.
the clickbait.
Turn off, get off social media, turn off the TV or put it on Netflix or something else other than the news. Don't watch the news.
No.
Don't look at the comments.
No.
It's going to trigger you to make a response. You're going to say something foolish.
You don't want to do that. Seek proper guidance,
Right.
guys, and make sure you listen to that advice. This is where I'm going to try to make sure that you guys, have those keys to keep in mind, because it's just vital. It's going to be crucial, especially if you have found yourself in this situation where you need that. Respect it and respect the process. And hopefully, you end up getting a good day in court where you can then present your case and get the result that you look for. Now, at the end of the day, guys, you have to understand everything that we do. We have this goal in mind to positively impact our community. And without these daily principles, without these daily habits, we would not be able to do what we do at this very high level. And so if you want to do the same thing, listen to this. We always looking for, some feedback, some comments, some critique. You don't like my hair? You don't like something that I'm wearing? Hey, comment it. I'm looking forward to that comment. So look out for the next one. We are looking to make sure that we can get the next leader, the next high top producer of a niche that's going to be local, potentially statewide. If you believe to be one of those individuals, reach out. We'd be more than happy to make sure that we can consider you. I'm looking forward to you guys, to talking to you again. See you soon. Bam.